work with him. But I'm being told. I mean, I can tell I don't know if he's probationable. I don't know if he'll benefit from the classes. I don't know. What do you think? He just seems to be very. Seems to have some. Seems to be a little slow. That's what I'm saying. I don't know. No, he's the one that made the threat. No, he's the one that went to y'all to fight.
Oh, okay.
Well, he said, "I'm gonna blow y'all brains out," but they didn't find a gun.
Okay.
And then the other day I saw him walking down the street, and I was just very concerned. By the way, I saw that.
He touched on if it hurt him with first even something.
All right.
Maybe.
So
he's on probation.
Oh yeah, are you gonna find? Did he find out what's going on with you?
No,
okay, so at least we'll get him on probation. Well, no, we'll do probation and you can find out. But if you bring him up, we can.
Okay.
All right, everyone, I'm going to start now. Thank you for your patience. A few important matters before we begin. First of all, I want to make sure you all understand that you have rights. Your first right is to remain silent when I call your name, though you do have to come to that microphone and your hands must be visible. You don't have to make a statement. If you elect to remain silent, what I must do is maintain a not guilty plea for you, which will move this to the next phase, which is likely an additional pretrial, but you also have a right to a trial. The trial is before me, unless you request a jury trial in writing within the proper time frame. Before either trial, you will know the evidence against you. At the trial, you can cross-examine any witness that the city calls, and you can have your own witnesses appear. And if you are not willing to testify or don't want to testify at the trial, you do not have to. And if you can't get your witnesses to come based on your request, we will subpoena your witnesses for you. So you have the right to remain silent, and you have a right to a trial. You also have a right to an attorney, which is why there's always a delay before we come out in the morning or the afternoon. We want to make sure whoever needs to speak with the defense attorney here has that opportunity to do so. But keep in mind, if you would like to hire your own attorney, I will give you the opportunity to come back with your own attorney. When I call your name, there are 4 types of pleas you can enter. The first one is not guilty, which resets this for another hearing or a trial. You can also enter a plea of guilty where you are admitting what you're accused of. And if you do that, I could sentence you today. A sentence in a municipal court ranges from $0 to $1,000 as a fine, 0 to 6 months in jail. That's the jurisdiction of this court. Anything above that is a felony charge. And that's on a guilty plea or guilty finding. There's also a plea of no contest that can resolve your case, the same possible penalties, but the difference is the no contest plea cannot be used against you in a later proceeding, which is why some people use that no contest plea. Then there's also a plea of not guilty by reason of insanity. If you choose that particular plea, we would have to stop the proceedings to see where you are in your ability to go forward. But keep in mind that plea is not available for your traffic cases. Moving to your traffic cases. If you're going to resolve a traffic case today, and if you get points, the B&B is going to be notified of your points. If you accumulate 12 or more points on your license will be suspended, and driving under a 12-point suspension in Ohio is a jailable offense. So it's important to know that. Also, you must have insurance to drive. So if your ticket is marked no for insurance, once the B&B gets a copy of it, you're going to receive a suspension. But what I normally do is give you 72 hours for 2 things. One is to come back with your driver's insurance information. You do that, we'll update the file. That way you'll avoid the suspension. The other 72-hour benefit is for a payment plan in the event that you cannot handle your fines and costs today. You come back within 72 hours. All I ask is that you make some type of down payment towards your fines and costs, fill out the form asking for time to pay, and I will extend that balance out for you. The other thing I want to mention in regard to driving is driving under suspension has been happening so much in this county that it's gotten very expensive as far as the penalties. The fines I've seen range anywhere between $500 to $1,000 fine. I've actually seen paperwork from other courts, $1,000 fine. You can get 6 months or even sometimes more of a suspension of your license, depending upon how many times you've driven under suspension. Some judges even give jail time. The bottom line is you want to do what you can to get your license in a better position. Try to get driving privileges or something to that extent so that you're not facing those penalties. What I do in this particular court is if we resolve your case, I try not to give you any points if that's available. I will not resuspend your license because you're already on suspension, and I don't give the jail time. So the key is try your best to get your license. All right, I think that covers it all. If there's anything else that you need to speak to the attorney about or the prosecutor, you'll feel free to have that time. Thank you. Marquise Carter. Mr. Carter is 19. Excuse me, 19 TRC 02627. This is alleging that on July 21st, there was an OVI offense as well as a traffic control device violation. You did show insurance. Counsel, for the record, how are you?
Good afternoon.
Your name for the record? Thank you.
Jody Gannett.
Thank you very much. Counsel, it looks like there's a resolution. Can you at least indicate on the record the resolution, or maybe even the prosecutor initially?
Yes, at this time, the prosecution moves to reduce this charge to physical control. The evening that this occurred, Mr. Carter was traveling down the street, and I guess he was upset about something and yelling profanities and whatnot out the window. The police pulled him over. He didn't immediately stop, but eventually he did pull over. And the officer who we've spoken to said that he was very cooperative. The issue in this case was that there was no other jurisdiction available to do the breathalyzer that evening. Officer McClamrock feels that Mr. Carter would have consented to do it had there been one available, but there just was not. And he was comfortable with reducing.
All right, counsel, anything to add to that? All right. So for the record, to the amended charge of physical control, how does your client plead? All right. So I'll accept the plea. And Mr. Carter, just so you know, based on all the facts together, and I know that counsel and prosecutor had a chance to talk about this case, at this point, it's very rare for me to amend a charge or accept an amendment from an OVI to physical control, only because one of my missions, I have so many, one of them is to try to curb the drinking and driving that's going on in our community, because it's just not safe for you or anyone else. But I think the facts and your current situation with the CDLs support this amendment, so I'm going to go ahead and do that. So on the plea, accepting the guilty plea, it'll be a $500 fine plus cost, 180 days in jail. The jail time will be suspended, and you're going to do a 3-day class. And I'm going to put you on probation for a period of 6 months to give you an opportunity to set that class up, because it's going to require some scheduling on your behalf. And that gives you a little bit of a window to set this up. The other thing I'll do, just because you're doing that, we always do a drug and alcohol assessment just to make sure that there's no issues that we need to address. And I really think that's more for your benefit. You know, sometimes you think of it as a burden, but if there's something going on, and we want to put you in the best position that you can be in. So that assessment will tell us if you need some AA classes or not, or even if you need treatment or something like that. But the bottom line, what you're benefiting today is that, one, we're going to amend the charge with the physical control. I'm not going to suspend your license, but there will be that short period of time for probation so that you can complete the classes. All right. Any questions about that, counsel?
Just after he finishes the class, that's when we come back possibly and mitigate probation.
Absolutely. I will be willing to do that because of the physical control. Absolutely. What day are we going to have to meet with Miss Ivory? December.
Will you meet with probation?
Yes. Well, normally we would set it for December 16th because Miss Ivory's here. I think, Miss Ivory, you have some other items to take care of today here.
Yes, sir.
All right. So let's set that for, and counsel, you don't have to be present unless you wanted to, but December 16th, Bailiff Sanders, what time is that? Monday at 9:30. Do you have that time available, sir? Okay. So yeah, just come on in. You'll set everything up. If there's something that you have questions about, of course, you can always say, hey, I want to talk to my attorney, and I'll give you that understanding. But otherwise, the case is pretty much resolved. And even with the fines and costs, you have the 6 months or shorter to take care of that. So you don't have to necessarily take care of that today, but you have that leeway to take care of it. All right. Anything else, counsel?
No, thank you. We're grateful.
Thank you very much. Take care, sir. We'll be working with you. Yep. Ms. Carter, you can step right down and see Miss Ivy for a moment before you leave. Yeah. You the best. DJ Khaled. Jesse Parsh, 19 CRB 00649. All right, counsel, good afternoon.
Good afternoon, Your Honor.
Can you? All right, so in this particular case, we had an aggravated menacing charge, again, which is punishable by up to a $1,000 fine and 6 months in jail. And I know we were here on a previous occasion and continued the case, and basically what the court has is that on or about May 18th, 2019, there was an interaction between your client and a Mr. DeFries in which there was a fit of road rage alleged, as well as yelling racial slurs and other threats, causing him to feel fear for his safety. Now, the aggravated menacing, obviously, as I mentioned, is a first-degree misdemeanor. On our previous occasion, we had a chance to hear from the city. At that time, there was a request on the record for the first offenders program, the cycle breakers program that we have here. And basically, the cycle breakers program, the difference between just a regular plea and the cycle breaker program is just what happens at the end. Most of the cases that come through my court, if there's an allegation of any type of violence or any offense that, of course, could cause some danger or harm, not only is those programs part of it because there's probation, there also could be jail time. So those are just some of the actual risks of these particular offenses. But of course, I take many other things into consideration prior to entering those decisions. Madam Prosecutor, just so the record is clear, last time we were here, we were in the midst of resolving the case, but then at that time, I did give the victim a chance to speak, and of course, the victim can have a chance to speak again today. And there was an objection to the presentation for the cycle breaker program at that time, and that's what caused me to reset the case for today. So it's my understanding, counsel, that today in open court, there's going to be a straight plea to the offense.
That's correct.
And no agreement or promises for the cycle breaker program at this time. All right. So for the record, Mr. Parsh, how do you plead to the charge of aggravated menacing?
No contest.
All right. So with that no contest plea, Madam Prosecutor, do you want to add a short factual basis just to support that, or is there a consent to a finding of guilt, counsel?
We'll wait.
All right. And I also just want to make clear, if indeed Mr. DeFries wanted to make a statement, he does have that opportunity. I know I've heard from him before, but I don't want to neglect to give him that opportunity again. Sir, would you like to make a statement? All right. As soon as this gentleman moves.
It's not just Mr. DeFries, it's also his wife. She was also in the car.
Okay. All right. All right. So you want to make is there a statement from either party? You can stand up, state your name, and I'll hear from you.
My name is Damon DeFries. We were coming from a funeral on the street here, Rosemont, wherever it's called. I was with my 80-year-old mother and my wife. We're coming from the funeral of a retired Cleveland police detective. We exited onto Euclid Avenue. We had the jazz station on, it was on low. We were speaking about the services. We merged onto Euclid, make a left. I started hearing somebody screaming and yelling. So I turned my radio down. I look up at my mirror, it's Mr. Parsh. His face is bloodshot red, beet red, screaming, "You black MF, you cut me off," arms out the window. The throat cut sign, "I'm gonna kill you, black MF," all the way. He's reaching under the seat. I could tell from here, he's reaching here. He's doing like this, then he's going to the blood department. So now my mother's like, "Damon, go." She's scared. My wife jumps on the phone to 911. We're going down Euclid. This is when they had the barricades up when they were doing construction. All the way down the street. "You black, I'm gonna kill you, black. You're from this broke, poor city." I'll never forget. "You're from this broke, poor city." So we're going down. We make it to Superior. He's still behind me. Same thing. Like just rage. Just like a rage. So I get to Superior in Euclid. It says no left turn. My mother's laying down in the back seat now. She's terrified. So I bust the left and go up Superior Hill anyway. This guy's behind me. I'm going around cars. This guy's behind me. Same thing. I'm looking at him from my mirror, this mirror to my wife's mirror. I'm going back and forth. So now I'm from Cleveland Heights. I bust the right on. There's all marks. So when I get to Mayfield in Coventry, there's a gas station here. There's two cars in front of me. He's still back there reaching and acting crazy. So I go through the gas station. Then I go across Mayfield to the store across the street to get away from the guy. The light's still red. I'm going across this Mayfield from the gas station. This guy follows me through the gas station, across Mayfield, through the store, across the street, and back down Coventry. He's still yelling and screaming racial stuff all the way. That's about 3 miles from here. So there's a police car pointing, facing out to Coventry and Marks. I pull up directly to her. Our windows are. I said, "This guy's behind us. He's yelling, blah, blah, blah." He pulls up right behind me. Ah! So she says, "Pull over." She radios for backup. She tells him to pull over. I said, "He might have a gun. He's been reaching under the seat since we left East Cleveland from a funeral." She searches the car. She's like, "He doesn't have a weapon." Now I'm pissed because now you're playing. You got my life in jeopardy, my wife and my mother. So police come, Cleveland Heights police come, I tell them what happened. I came back down here, and that's when I filed the charges. Because this man is dangerous. If he's ever in the right situation, he will definitely do something to somebody of color. There's no doubt in my mind.
All right. Ma'am, you want to make a statement also? You can state your name for the record.
My name is Watanya DeFreeze. This is my husband. And yes, on that day, he was acting like that everything my husband said is true. And I was on the phone with 911 the whole time. So they should have recordings of everything that I stated to him, what he was doing, like he was reaching for a gun, everything. So everything should be on record, what I stated with 911, because I was on the phone with them from the time that he was trying to run into the back of our truck in East Cleveland where he's doing the construction at, all the way up to Marquise.
Okay. Thank you, ma'am. Appreciate it. Also, is there anything else that you'd like to say or your client at this time? I know that you've spoken with the prosecutors. Anything, any different version? Or
We have our version of facts, and it would be useless probably at this point to try to add gasoline to the fire.
okay. So at this point, you're resting with your plea of guilty to the charge. Okay. All right. So what I'll do is this. I'll go ahead and accept the plea. And Counselor, it looks like there was a bond posted. How did that play out? Did your client spend any time in jail, or what happened?
No.
You posted the same day?
He was charged some other.
Okay, it was a prosecutor. Was it a prosecutor warrant, Ms. McCullough? How did he get?
Yes.
Okay, and so then you came up and posted a bond. All right, so what I'll do is there'll be a finding of guilt. Wondering. 180 days in jail, but what I'll do at this point, I'm going to suspend the jail time. It'll be 12 months of probation. We have anger management, the Finish First program. It'll be a $750 fine. And Mr. Parsh, the thing about the probation, obviously, you have to comply with everything that Miss Ivory is going to tell you to do. Part of the anger management, that'll be something she'll set up. She'll tell you about that. But the Finish First program takes place in this courtroom on Monday nights at 5:30. I present that program as well as one of my magistrates. So that'll be the program that I'll be with you in. And then there's a program and various programs that Miss Ivory has set up also. And what I'm gonna do right now, I'm gonna put an initial probation period that we can review, Miss Ivory, upon your status of 12 months. And obviously we know that either extends if there's non-compliance or if there's some other reason, we can go the other way. But normally that's the probation period, 12 months. What day we have them report? December 16th at 10:30. And just like with the other case, Mr. Parsh, counsel, you don't have to appear to the initial meeting, but if you'd like to, you could. But again, it's for the purpose of setting everything up. So at the end of the day, I wasn't there, obviously, and I know even when you were here the first time, your version is basically totally different. But we have to be careful how we deal with individuals, because not only, obviously it's dangerous, but at the same time, unless, to be honest with you, unless you're looking for a shootout, to be honest with you, in East Cleveland, I'm just saying, let's say the facts are what was presented. You're more at risk of that type of behavior, of being a victim in this city than, the way Mr. DeFreeze says he handled it by trying to go and find police officers. I'm just being honest, I grew up in this city. Most men in this city presented with that same scenario would have said, okay, let's pull over. And then you would have been forced to, your hand would have been forced one way or the other. And then, of course, if you have a weapon, based on what I do here every day, to be honest, 90% of the people walking through these doors have weapons at some point. It's not a good thing. But so now what's the end result? We have two people shooting each other in the city of East Cleveland. I've had scenarios where people have pulled guns at each other at Popeyes, and this is way before the chicken sandwich came out. I'm just saying, just being mad at each other. So that's what you want to avoid, and that's what's at risk. And the last thing I'm gonna mention, because we all to bring it down, we all fall victim of this road rage thing. I mean, there were times, especially when I was an attorney before I became a judge, I mean, I would pop off so quick. But you got to remember, at the end of the day, if you don't know that person, they don't know you, it's never personal. It's really a mistake, or they weren't paying attention, even accidents. I mean, I've seen people get in fights over car accidents. Nobody really wants to damage their car by hitting your car. So to add on top of that anger and fighting, it's really unnecessary because it's not a personal offense. So if he cut you off, I'm sure he didn't mean to, or if he did, he wasn't going to say, this is the guy at this time that I'm gonna cut off because I don't like him. You know what I mean? And that's how we have to deal with this whole road rage thing, because we all can fall victim. I even have to tell my wife that sometimes, to be honest with you, because she gets a little mad, but it's not personal, and you should never take it to this level. But that's where I am with it on this day. I'll be working with you, Miss Ivory. Can you speak with them in regard to probation? Counsel, anything else?
No, thank you.
All right, thank you very much.
The first thing we
Mr.
have to
Freeze,
do
thank
is
you.
December 16th.
December 16th will be the date to set everything up,
Okay.
put everything in motion, and then we'll proceed as we discuss. You're welcome. I'm sorry. Yeah, you can have a seat until Mr. Parsh, you can have a seat, and then Miss Ivory will call you up in a second. You can sit right there for a moment. All right, Mark Hemmons. Mr. Hemmons, how are you this afternoon? Excellent. Come on up to that microphone. Mr. Parsh, when you're ready, you can come over and see Miss Ivory, and then you'll be ready to go. 19 CRB 01438, disorderly conduct. That on or about November 27th, you were causing disturbance inside of a location, cursing, yelling, and threatening, and you were under the influence at the time. Madam Prosecutor, can I hear from you? Because this is normally a first-degree misdemeanor where you're looking at a $1,000 fine and 6 months in jail, but the city has amended this to a minor misdemeanor of disorderly conduct where you're not looking at any jail time, and the maximum fine would be $150. Madam Prosecutor.
The amendment takes into consideration that the report's basically stating that Mr. Hemmons was a little inebriated at the time, and he was just arguing. He says there was an issue with his girlfriend who wasn't on her meds at the time, so I think it just got a lot of hand.
So it didn't get violent, Ms. Hemmons? All right. All right, so how do you plead to disorderly conduct, the minor misdemeanor?
No conflict.
All right. Are the two of you still together?
Yes.
Okay,
So
all right.
what happened was
Go ahead.
she 2 days before Thanksgiving she ran out of meds. And when she ran out of meds, like I told her, you don't supposed to go that long without them. She just got her new meds 2 days ago from that time. And we both mental health. She's very bipolar.
Okay.
And she wasn't feeling well. And all I know is I ended up here for 4 hours, and I'm today.
Okay. Well, a couple of things. Acknowledging what you said. I appreciate you being honest about the health condition, mental health condition. That's important. But I'll say this because you're presenting very intelligently right now. I would hope that if this happens again, that you would be able to say, okay, you know what? She's not taking care of her business appropriately, so let me deal with her a little lighter. So because I know she's not on her meds, I'm not going to yell, I'm not going to scream, you know what I mean? Because it seems like you could be able to do that you can control yourself. So try. That's all I'm asking. Go ahead.
I walk away.
All right. But this time you walk after yelling a little bit. Okay. All right. We'll continue to try that. So what I'll do for you is this. I'll accept the no contest plea, the fine of guilt. Because of everything involved, and you still live at the same place?
Now we just moved from there on the 29th to a beautiful home up Cherries,
Okay. In East Cleveland still?
Cleveland Heights.
Oh, in Cleveland Heights. Okay, so you're out of the town. So excellent then. I congratulate you on that.
6 years.
You were there 6 years.
One room, me and her.
All right. Well, I mean, honestly, that's a huge accomplishment. Really, congratulations on that. That's commendable. So that shows that you know how to handle your business and you're moving up. So I appreciate that. So this is what I'm gonna do. Ms. Hemmons, as opposed to a $150 fine, as long as you guarantee me the two of you aren't gonna be fighting anymore, right?
Yes, sir.
All right. It'll be a $20 fine plus costs, and you're free to go. All right. You take care. Okay. DeAndre Hughes, not here, right? Mr. Hughes is not present. 19 CRB 01401. Ladies, can you come up one more time? And we'll also have Dominique West coming up. Ms. Johnson, how are you? So, ma'am, for the record, can you identify your name and what you do in this regard?
Amanda Kupchak, and I'm a forensic liaison with the County Board of Developmental Disabilities.
Okay. Now, are you working with the hospital, or you work with the county specifically?
I work with the county.
Okay. And Ms. West is one of your clients?
I
All
work
right.
with this.
All right. So basically what's going to happen today is because Mr. Hughes is not here, there will be a warrant issued for his arrest. And it's my understanding, Ms. Johnson, he's been contacting her?
He's been contacting her all day.
Okay.
He's been contacting while he's supposed to be here this afternoon. I even took the phone myself at one point in time when he did call. I answered the phone myself. I spoke with him. Asked him, did he understand that he was not supposed to be contacting her because of the temporary protection order? He stated that he did understand, he was sorry, and then he hung up.
Okay.
I did proceed to go upstairs, call the same number from the prosecutor's office, and I asked him, did he know that he was supposed to be in court today? His response, and I quote, was, "Oh man," and hung up the phone.
Okay. And doctor, those are your colleagues?
Oh, yes.
Okay.
Yeah, we all.
All right, so a warrant will issue for his arrest. But one thing I just want to mention, I don't know, I'm just, even though he's not here, I'm not going to go in. Well, we did have evaluation done that came back inconclusive in the sense that we can continue to go forward. So there's nothing wrong in that regard that would stop us from going forward according to what we received. We'll go over that in more detail. But what I do want to mention, and Ms. Johnson knows this, I find it so sad because situations happen and they don't always have to end with someone going to jail. Because, you know, luckily these two had it out and it wasn't seriously violent. You weren't seriously injured. But what's bad is that the violation of my order of no contact, not coming to court, that's going to cause him to spend time in jail when maybe we could have worked this out without jail time. I just find it, you know, terrible that he's not coming to court and that he's still calling you, because that's the reason before anything else that he would end up serving time for violating my trust and letting him out and violating my order of not to contact you or bother you when you don't want to be bothered. So once we get a hold of him, prosecutor will be in touch with everyone. You have everyone's numbers?
I believe so.
Okay, Ms. Johnson does. All right. Well, thank you so much for your time, ladies.
Well, thank you.
Colette Johnson. Ms. Johnson, how are you? Ms. Johnson, what was you here for before? I did not see you recently.
I need a job here.
I know. What was it? It was, but it was something. What was?
She missed her probation appearance or something.
Yeah,
Okay.
but that, I've been here 50 times.
And
they
didn't know
miss
about
that
this.
Every time.
Yeah, somehow or another that got slipped through the cracks when
Like
she
every
appeared
time
on
I
her
go.
other traffic matter. So because of that, that's why.
So 19 TRD 01047 will be dismissed. And I will say, I'm gonna dismiss the case, but I never remember the cases unless they're really crazy. So I was asking my bailiff why you were here. That's a good thing because I don't walk out of this courtroom holding any judgment, but I remember you because of your smile. So that's how you want to be remembered, not because of whatever craziness goes on. So this case is dismissed. Free to go. Take care.
Thank you. See you later.
Logan Jones. And the middle name is Aaliyah. Okay. How are you today? Your first name is Logan? All right. All right, so Ms. Jones, what I have here is a charge of criminal damaging from November 26th, where they were alleging that you drove your vehicle into it looks like they're saying a home on 141st Street, causing damage. Now that's a first-degree misdemeanor, which means you could get up to a $1,000 fine and 6 months in jail for that. And you're 19, correct? It's my understanding you're entering a plea of not guilty, correct?
Yep.
Did you graduate from high school?
No.
Are you still in school at all?
No.
Are you working? Okay. Your pretrial is going to be December 30th at 9:30 a.m. We'll see you back then, okay? Take care.
Okay, you might recall Ms. Jones, I just realized that there should be a traffic matter that she was supposed to have appeared on yesterday. So let's see if I can pull in that, so we should take it to the other.
You know what we'll do then? Since we have the December 30th date, I'll let the bailiffs know. We'll pull it and reset it for the same day. That way you don't have to do that. So keep in mind, you're coming back for 2 cases then on December 30th, correct? Okay. Thank you, Ms. McCullough. Kalanta Morris? Ms. Morris, I have a couple of cases here. 19 TRD 04747 is driving under suspension and a speeding. They were alleging that on November 26th, you were driving without a valid license and you were going 53 in a 20-mile-per-hour zone. And they marked that you didn't have insurance. And I understand we're entering pleas of not guilty at this time. One thing I will tell you is that by the time you get your case resolved, you want to do your best to try to have license and insurance at that time. Because even if we resolve your case, I don't have to suspend your license. But if you don't have insurance, the BMV will. You understand that? So that's the February 5th. It's just coming back. So we're resetting that for February 5th, right?
Yeah.
So we'll set that for 1:30 on February 5th. And then we have another file, 19 CRB 01445 from November 26th, alleging a disorderly conduct. That's where they're alleging that on November 26th, you did scream profanity while in the presence of other people, causing a disturbance in the city of East Cleveland. And it looks like the city prosecutor is willing to amend that charge of disorderly conduct as a minor misdemeanor. Madam Prosecutor, can you make a record?
Yes, these happened at the same time. The disorderly conduct came out of her interactions with the police. She wasn't happy about the over and the tickets, and so she was a little disorderly and acting ugly and saying things that I didn't like. So.
Okay. Ms. Morris, you're 20? Okay. You graduate from high school?
Yes.
Are you working or in school now?
Both.
Okay, where are you in school at?
Tri-C.
All right. What are you taking up at Tri-C?
Nursing.
All right. So to the charge that the city is amending from a first-degree misdemeanor to a minor misdemeanor, how do you plead to that?
Guilty.
All right. So tell me what happened. So I have that you were going 53 in a 20, and then you were mad because they pulled you over?
I don't know. I was irritated. My baby father had left my kid at school when he was supposed to, and we was just arguing. So if I was driving fast, I probably was. But when I got pulled over and I told the officer that I didn't have my license, he just grabbed me out the car, just like rough with me, both the officers. So at this point, they was taking my car, taking my license plates, taking my driver's license. So I'm left on Lee Road right there by the store. In they cars. My car's already going with the St. Clair auto body. So at this point, I'm upset, yelling on the phone, but I'm yelling on the phone with the people that's supposed to come get me because I didn't want to ride here. I just wanted somebody to come and get me. So me yelling and all that, I was upset because my car was taken. My kid was still at school, so I still had to have somebody come get me, come take me to get my kid. So there's so much frustration that I was upset.
Okay.
So and I was yelling and all that.
How old is your child?
He's 3.
3, okay. Did somebody come and get you?
Mm-hmm.
So they did at least allow someone. They didn't arrest you.
Somebody came and got me. I was still on Lee Road. They wanted me to ride. Well, they asked did I want to ride here or ride somewhere, but I said no.
All right.
I will have somebody come get me.
All right. So what I'll do is I'll accept the plea with a fine of guilt. As opposed to a $150 fine, I'm going to take off $100. It'd be $50 plus cost. And then I'll see you back when we deal with your traffic situation, all right? So you don't have license right now, right?
No, the only thing I have to do to get my license back is pay my SR22 bond, and then that's when my license gonna be back valid. But I didn't have it at the time, and it's $400, and I had to just move. So
Okay.
I just moved first.
So make sure you do your best because, some of these cities, again, just like you did here, they'll leave you on the side of the road or you'll let somebody pick you up. But imagine if you're with your child when that happens. So you want to get your license so that you're riding without that fear of being stopped. All right. So do that and we'll see you back in February. All right. You take care. Toshay Williams. Ms. Williams, how are you?
I'm fine.
Excellent. Domestic violence, Madam Prosecutor, what's going on?
This case came out of kind of a tragic situation where there was one lady and her husband. One party, they're out. It starts off with her aunt and they're out. Well, I wasn't meaning that. This starts before this particular evening.
That's my aunt's daughter.
Okay. So they get into some type of physical altercation after a night at the fireside or something. And that lady tried to charge that other party with an assault. Approximately a week after that, she died. So there became a kind of a split among the family, with some family members believing that the other party caused her death by having this altercation with her. And so there's been this kind of rift in the family since that time period. Miss Williams goes to the fireside where her aunt is working and they have an argument, and what was alleged was that Miss Williams threw a cup of liquid at her. There was a video that showed that. And at the time when this happened, because I knew that there was a lot of emotions involved in all that, I tried to, do you really want to charge? She was adamant, yes, she really did. Well, weeks pass and emotions calm down and she's no longer interested in it. It was a really minor thing that happened at the time. And like I said, I think it was born out of the grief that was happening in the family and the rift.
Okay.
So
Ms. Johnson, did you get a chance to speak with Ms. Stewart?
Since the beginning of this case, I've tried to reach out to Ms. Stewart multiple times. Each time there was a busy signal associated with the number that I had. So I haven't been able to locate her.
And for the record, Ms. Johnson is the victim's advocate. So Ms. Williams, how are you and your aunt now? Are you getting along, or are you just not? You're not fighting, right?
Can I explain it?
Yeah, absolutely.
Better understanding.
Yeah.
So my aunt's daughter, her name is Rosalind Stewart, and she jumped on my aunt Roberta Williams, and it was in the city of East Cleveland. My aunt died 4 days later after Rosalind jumped on her. So when she passed, I was telling my aunt's Rathina brother that I wanted to see if they could pursue the charges because she already came here. Like, they took pictures, my aunt, before she passed, she came here. They had everything. So it got back to Rathina. Now, June 4th, on the incident, it was my aunt Roberta that passed birthday. So we was there to do a balloon release. When my first mom said, don't even go. Let's start following my first mom. So when I go, anyways, my mom had called me and her son, which is my aunt Barbara's only son, the one that passed. So I'm like, all right, I'm just going to go up there. My nephew just came home from prison, and his girlfriend gave Rathina counterfeit money. So Rathina said she was going to call his parole officer about me. So I go, I'm like, auntie, me and my aunt been pretty cool. Even though her daughter did this, we have always been kind of close. I don't really get into it with aunts and stuff like that. So, I told him, like, that ain't right. You don't do that to somebody that just came home. You can send that boy back to prison. She was like, well, our family. So I did say some things to her that probably upset her. Like, she slept with my grandma's husband, made him get a divorce. So a lot of things, probably upset her in front of the bar. She came down here. She pressed charges. I never did nothing to this woman. She didn't come today. She sent apologies through my mom multiple times. I really ain't try to hear it. I didn't try to call her or nothing because from my understanding, I was supposed to have no contact with her. So I guess she want to apologize or whatever, but I'm really not ready to hear her apology because not only that, 2 weeks ago, I went to go file because somebody stole my purse at South Euclid. They arrested me, said I had a warrant for East Cleveland. East Cleveland came and got me, brought me here. They didn't take the warrant out the jail, but they took it out the court. So I ended up getting arrested. That day, I was supposed to start a job at McGregor for LPN. No call, no show. So you know what kind of, then I'm in school to be a nurse. So it's kind of like, I just want to get this out of the way.
And it sounds like in all of that, you've at no point admitted that you threw a glass of liquor at her.
I didn't.
Okay. And just from what I gather, putting that all together, then on the other end, the prosecutor at this point, even with the domestic violence advocate, is unable to put this case together without the victim cooperating. The victim isn't cooperating with you and doesn't want to go forward.
Can I say one more thing?
Yes, ma'am.
The officer that came on site, if she read his report, it says when he came there, she wasn't disheveled at all. There wasn't no broken glass. Her shirt wasn't wet. It was nothing. The lady, Barbara Johnson, which is her friend that works in the water department, coached her. And the officer was like kind of upset, about that. And he said if I needed him to testify, just say so, because when he came, there was completely nothing. Okay.
Well, I will accept the dismissal by the city. Okay. So the case is over. You're free to go. So it's actually dismissed, so it shouldn't even be on your record. But you may have to take some steps. You may want to talk to the attorney, or I don't know if Ms. Ivy's available about you, because you were arrested, correct? So you may at some point want to try to get that sealed. That doesn't have a lot to do with the court, but you may want to seal that. You don't have a record, but there will be a record of your arrest. I don't know if that will delay you in what you're trying to accomplish in the future, but you may want to check into that.
Well, the officer that kind of picked me up from, you talking about from South Euclid?
Yeah.
I already been to court, so with the error,
So you won't.
they forgot to take the warrant
out. Okay.
What I'm saying is you may want to,
still-
nothing
she
else,
still
even
was
if you
brought here
don't
and
choose
booked
to
in.
get the arrest expunged, you may want to get a copy of the journal entry today,
She was booked
because
in.
sometimes if they see
That
an
was
arrest
like
for domestic violence, they'll take it and
For what?
treat you like it's a conviction when it's not.
So
you
Ms.
may wanna
Ivory,
do that.
yeah, she has a pamphlet right there that you can use and take a look at. Because basically the fact that you were in any type of custody could be used against you later. And it may not be, but just so you know. All right.
Your nursing license, you've been-
I got 8 months left.
I suggest you do it, yeah.
Highly suggest you do.
You've seen the ones you get.
That's why I try to be careful. I miss another hospital.
Okay. Go on.
All right, Wesley Shields. What's going on with the Shields? Shields, good afternoon. Mr. Shields, were you doing did you do the classes? Were you doing some, what's going on with that?
Start one class tomorrow. I don't know what it is, and then the other class is gonna start till January.
All right, Mr. Medley.
Yeah, Your Honor, he's here today, needing to basically give us a status of his progress with CFS. And I've spoken to Ms. Eppinger. I've been keeping in touch with her. And as of now, he is in compliance. There was he had to do a couple of things. He had to assessment. Haven't got the results back on that yet. There's still ongoing, it's pending as far as the results. The drug test came back. He was positive for THC, which was to be expected. We all knew that the going in, the CFS case manager, she knew that he was forthright with her and let her know that he would likely possibly be dirty. The thing with that though is that he, through his explanation, he was leading to lead us to believe that it was, it was 6 months ago, with his hair, and not recently. He's far away from that, removed from that now, which isn't the case. He's been smoking or been having some type of THC or substance use in the last 30 to 45 days at the least.
Okay.
So that's just concerning as far as him being forthright with the court. That's a composing issue going forward. But as of now, though, he's in good standing, and he has an appointment coming up this Friday
with the case manager at the hospital, and we're going to go from there. I'm just going to continue to monitor.
So probation is doing well.
Right now,
Okay.
he's in good standing. As of now, today.
So with that being resolved, okay, so we go with probation. Then we also have the new charge, right, 19 CRB 00988. Madam Prosecutor, where are you in regard to that particular charge? We set this for trial. This is the
Right.
second trial date.
Right. Ms. Pinckney contacted me yesterday thinking that the case was set for the morning and told me that she had an appointment at 11:30, and I informed her that it was actually set for this afternoon and that she should have had plenty of time to get here, and she still is not here. She's basically been a reluctant victim from the start. I believe she only went forward with the charge because Children and Family Services was involved and she was concerned that they might take the child away.
All right. So what I'm gonna do, because he's on probation and you're moving in the right direction, let me reset that one final time and give her a chance to get here. Just I want to make sure nothing else is happening on that end. I know that'll be a court's decision because at this point, and I assume there's an objection from the defense, so I won't need that. And let me set this for a status / final trial on that last one. It'll be January 23rd. Probation docket.
19.
You're doing the
No,
23rd. Well, we have the 30th also.
Third Thursday.
The third one would be the 16th.
Okay, 16th, yes.
January 16th.
Oh, Jan-
Well, hold on. So
I'm sorry.
So it's the 4th.
About December. I'm sorry.
your birthday is January 23rd?
Yeah.
Oh yeah, what do you plan on doing for your birthday? You look like you got some big plans, huh? Just don't want to be in court.
It's too cold outside.
All right.
Whatever that 4th Thursday.
Well, what I can do is we could set this for the 20th. We can set it for the 30th. As long as you don't do nothing crazy on your birthday, right? I'll set it for the last Thursday in January. Just make sure he's still complying. We can get all that information, and that'll be a final trial date. All right.
Thank you.
So we'll see you back January 30th at 1:30. Dennis Walker. Mr. Walker, good afternoon. Good. All right, Mr. Walker, you don't have a seat. I have to have the prosecutor in. I know we're set for a trial today on these cases, so we'll see where we are. All right, Emmanuel Tipton. Come on up, sir. All right, so Mr. Tipton, we're going to get your cases resolved. I had you come back because we knew there was an old case out there. So basically what I have in front of me are two cases from this year. One was in July 17th. The other one is November 20th. In July, there was a disorderly conduct and obstruction of official business. At that time, you told me you were on probation to Euclid, right? Are you still on probation to Euclid?
Yeah, I'll get off to next year, July.
2020?
Yeah.
What do they have you doing on probation there? What are some of the things you're doing?
They got me with cafeteria,
Okay.
but I ain't been in contact with the dude. I've been moving from house to house.
All right.
Yes, I've just been out.
But you live in East Cleveland, correct?
Yeah.
Okay. 'Cause I think I saw you the other day on the street right next to the court. You live on that street?
No, I live in ABC.
Okay. Okay. Who you live with? Your grandmother? All right. All right. So, Mr. Tipton, this is what's happening. Right now, we're able to get your cases resolved. The inducing a panic, which is a first-degree misdemeanor, which means you could get up to a $1,000 fine and 6 months in jail. The city is willing to reduce that to disorderly conduct if you want to resolve a case today. And then what will happen is on that old case, that's disorderly conduct and obstruction. We can resolve that by you entering a plea to disorderly conduct. So we'll be 2 disorderly conducts, and that'll be the end of it. But we'll end up, what I'm going to do, just to let you know, I'm gonna have you come into the program that we do here, that I do here, called the Finish First program. Because Mr. Medley, he's not on probation right now, correct? So you spoke with the defense counsel, Ms. Conwell, correct? And so from you to the charge of inducing a panic that's reduced to disorderly conduct, how do you plead to that? Do you admit to that?
Yeah.
All right. And the other disorderly conduct from July, you admit to that one also?
Yeah.
All right.
Somewhat, yeah.
So I know we talked about what was going on at the school, right? And you told me why you went up there. You haven't been there recently, correct?
No.
Are you working currently? All right. So let me do this. I'm going to have you meet with Mr. Medley just so we can see, you know, how we can map out a plan. Because basically, how old are you, Mr. Tipton? 20. I want you to be able to plan with Mr. Medley best that you can how you want the next few years of your life to look, and whatever we can do to assist you along that way. That's why you're going to be seeing him, and you're going to come into my class, because my class is not only about avoiding negative interaction with the legal system, but it's about leadership skills, so that you can be 20 years old, but you get on the right track and knowing exactly what you want to be doing in the next 3, 4, 5 years of your life. Do you know what you want to do right now? What you want to do in the next 5 years?
I don't want to go back to my hometown.
Where's your hometown?
Detroit.
Okay. And what you want to do when you get back to Detroit? All right. So that's some of the stuff we're going to work on. I mean, because it's cool to move. Sometimes you don't like one place, but moving is not the plan in and of itself. It's part of your plan. All right. I want to get back to Detroit, and then I want to do X, Y, and Z. So let's try and set you up with that. And I expect you to be at my classes and go to probation because you don't live far. So I don't want you to miss anything. All right. Go ahead.
Would there be any type of assessment possible?
You can. Anything that once you meet with him, I'm giving you that open door in that regard. And because I know he's working with Catholic Charities, at some point he will be. We can wrap around with that too. That way, once he gets involved with Catholic Charities, Mr. Tipton, we're not giving you a million things to do for us and a million things to do for them. We'll work it all together. All right? Because at the end of the day, I want you to be in a position where your life is so on track, and you know what you want to do, that you won't be in any disorderly conduct situation. Somebody calls you to go to the school, you won't go because you'll be like, look, I love you, but hey, I'm about to work on X, Y, and Z, so I got to help you another way. Maybe I'll call the police for you. That's the type of decisions I want you to make. All right, so to the disorderly conduct, there'll be findings of guilt. Right now, it'll be a $100 fine on each one, but the fine is not important. Mr. Medley, when you meet with him, talk with him about the Finish First program, MEG, and any assessment. And I want to know Mr. Tipton's ability to help us out when we start doing our snow removal, when we start shoveling the snow. Mr. Tipton, every year when it starts snowing pretty bad, me and these other bailiffs you see in here, we go out and we shovel snow. So, you know, we figure a nice, strong man like yourself can help us out. It's like a little bit of a workout. You can handle it. We get you there. We get you there. And you stay with your grandmother, right? So that's what we do. We shovel snow. You know, your grandmother lives in an apartment, so she don't need it, but it's a lot of grandmothers calling us, and we try to look out for them. So we'll keep you in mind for that too. So step down there and speak with Mr. Medley, and we'll go from there. Yes, you do. The 16th at 11:30. All right. Mr. Medley, he's close to us. He don't have no reason to miss nothing. I see him walking down the street. You see him. All right. So I have Mr. Walker's case. Are we ready for Mr. Walker's case? It was set for trial. Dennis Walker on a damage to city property as well as assault.
These are 2015 cases. I've attempted to get a hold of Ms. Reeser. She's been subpoenaed multiple times for this. I tried to call her. I don't believe the number is working anymore. And I don't believe at this point that an additional date would help me get her here any quicker. So at this time, we'll dismiss it outright.
All right. So in 15 CRB 00557, the city prosecutor is dismissing that one. And what without prejudice basically means is that in the event that the city found out that there was some other information, or you were asking this person not to come to court or be unavailable, they could easily bring these charges back up. So other than that, the case is dismissed. You can go to the clerk's office. All right. Take care, sir. Shayla Rosado. Ms. Rosado, good afternoon. 19 CRB 01319, resisting arrest, obstruction of official business, and disorderly conduct. Oh, we're ready for trial? Oh, Mr. McCullough, we're ready for trial on this one? All right. Ms. Conwell, we're ready for trial, or how are we proceeding? Ms. Rosado, you're ready for trial? Okay. All right, so I'm gonna have you come sit here at the table. So, Ms. McCullough, this is Ms. Rosado. We're ready for this trial, or?
Yes.
I know the officers.
Kind of make a boo-boo and kind of put the cart before the horse on Ms. Williams. Ms. Stewart is here now.
Okay.
And this was actually set for 3:30. So.
And that's the case of justice. Yeah.
All right, what about the gentleman in the back?
Oh, that's Mr. Daniels? Okay.
And so that's Mr. Daniels.
I believe that's the second, right,
All
second
right,
date on that.
so we can call that. So, there's no subpoena on this one for the officers.
Right.
So this is
the subpoena. There wasn't a subpoena for the officers. It was for a different party that was alleging an assault. But yeah, we would ask for one more day to at least get the officers.
Mr. Daniels, come on up. And what I'll do, Ms. McCullough, before we start the other trial, I see counsel's here for our trial tomorrow. If the two of you want to talk, or maybe for a moment, and then so you could, I'll do that. I'll set a date. I'll get that for you that way. Yeah, go deal with that. See if we can get that resolved. No, you can get them out here. But I say go ahead and do it now that way. All right, Mr. Daniels, basically what happens is in 19 CRB 01137, I normally give each party a chance to ask for a continuance. We set this for a trial today. The city is asking for their first no fault continuance. What that basically means is if you come back in and the city's here, the officers are here, everyone's present, you're not ready, you can say, Judge, I need my continuance. I have no problem doing that. What I do have a problem with is after continuing the case and I see no movement and I see subpoenas not being answered, I don't continue to give continuances at that point. At that point, I'm looking at dismissing the case. So right now, I'm going to reset it for one continuance on their request. It'll be January 16th at 1:30. All right. Any questions, sir? That's the victim. So a couple of things. You may want to keep that or did you get a chance to see that, counsel?
I haven't, and I don't
What's
know
that
if
date, the
I'm gonna
16th?
try it, and it depends, because if you give it to me,
Right.
it's gonna get lost.
So
I can guarantee that.
this is what you at 1:30. Mr. Daniels, keep that so that it's handy because we don't know which attorney will be here on that particular date. I'd rather have the attorney look at it first. Keep that. The 16th is the next date, and we'll address that when you come back. All right, we'll see you then. So we're taking a little bit of a breakdown right now. So Ms. Conwell, even if you tried your best, you would lose that? You gave a guarantee, like look, if I put my keys down, I guarantee I won't find it. I understand. You got a lot of cases.
I got a lot of cases, so I don't want to be responsible.
I understand. Yeah, but I don't even want to hear from the lady. That was Heather's
No,
mistake.
she ain't you. I'm just.
Yeah, I ain't that
I'm just
crazy.
explaining to her like, that's you go up there. Because her to me was, oh, I think she should have been punished. Throwing a drink in my face.
Go up there, tell her to make a complaint, make a fuss.
You didn't have a good night before you called. They've been sending you subpoenas. I ain't been getting that.
She must have got it because you're.
It's first one she got.
That's crazy. I can't believe she did that. So Miss McCullough dismissed the case. The victim got here right after. Yeah, I guess she'll spend some time talking to you. So what's going on with that? Is there a way to resolve that? No.
Yeah.
When
Wants to
today?
go ahead and do first offenders.
I mean, because if it was telephone
My
harassment,
thing is, put the plea on record today, because that's what we got derailed the last time.
right? Exactly. Is she here?
Yeah. And then I could see if Miss Butler can come in tomorrow. I don't know, or if you want to set out for a different day.
For which one? I'm sorry.
I thought we were talking about Miller.
Yes. Now, what did you say about tomorrow?
Well, it was set for trial
Right.
tomorrow.
Right.
And so Miss Butler is here today, so I don't know if you wanted to go do the sentencing portion of it and give her a chance to put it on the record.
Yeah, we'll put that on the record today and have her come back tomorrow for the sentencing report to hear from the victim.
Right. And everybody go.
Absolutely. She won't enter her plea.
She went to Virgin program now. We went through all this. It's a lot.
But she wasn't in jail anyway, so it saves us a day of correct.
You'll have all the two people in here.
Yeah, and what I'm gonna do is I'm gonna actually get something for this jury. And I'm wondering, I would love to figure out if we could figure out this other trial, this GE trial. And I would love to be able to hand each person a return date. But he's not here. We don't know which attorneys. Marlene's handling the case.
Right.
So yeah, if we could figure that out between now and then, I would love to give everybody something for coming, as well as I'll see you back February, whatever. We have a pre-trial in January. So if I maybe throw out a February date, I would love to. Yeah, if I can put some in their hand.
I mean, but you can't put that, but you can still leave it on the list. What should your assistant be called? Should be called.
Yeah, and hopefully they'll do that. You know what I mean?
You never know.
Right. So basically, that's gonna be $700. I'm sorry. I don't have it. Oh. She's gonna be found guilty. Yep, court is in recess. I'm surprised that that's a bad move. And this is the one that testifies very well.
Right, that's why I say the other guy wanted to cover. He was this arrest. You can't have a soul.
And I need Queen Miller's Is she coming back? She must be. Yeah, I need something so I can call the case, or at least a printout. So I just call it, just print the document, and I'll journalize it later. Yeah, I just need a case number and all that.
Judge, that was Mike Ward. He told me to tell you that.
Oh, hello.
He said drug court is calling him.
So we love it. So making him a.
Because in fact, that guy, the guy last week with the PCP who kept saying, I'm scared to go to jail.
Mhm.
He showed up on time yesterday for probation. The guy with the PCP, been using for a long time. The one who kept saying he's scared to go to jail.
Yeah.
It's going to be hard to get off.
The one that we really want to help.
Yes. He showed up yesterday on time.
Okay.
Some paperwork he couldn't figure out. And he has mental health doctors and stuff. So I was just talking to Mike about him because we had another guy who had CMHA housing that was afraid that he was going to lose his housing by going into residential that they took down to Springfield, Ohio for his residential. Mike's program paid for his rent 6 months.
Wow.
So he won't lose it. And see, that's one thing, but Mr. Land is afraid of because he has eaten housing. That's what I was telling you that we deal with already that Mark was talking to you about.
Right.
He has eaten housing. And Mike is like, we'll pay for his rent. He ain't got to worry about it. But now who did not show was the girl who was prostituting, soliciting.
Oh yeah, I'm
And
pretty sure.
Mr. The other guy who'd been on probation forever, who stood up with a little skinny guy, gonna be there. Them two didn't show. So I'm okay is in there.
Okay.
I'm sorry, Jim.
You're fine.
Yeah. In some strange way, I like those.
Yes, it. No, yeah.
Okay, yeah. Do you have some information? Okay. Okay.
The real way.
Okay. PO Box 6505058. My last name is spelled.
You know, I'm trying
4410.
I'm trying to be
And my last name is spelled
lenient
LLOUG.
right now. They keep tagging it
Yeah.
away. But even with
Yeah, that is great. Just step right outside. I'm going this country all the way.
I think what we're gonna have to do at some point, man. Maybe it's gonna be no phones. Even with her, man. On these.
That would be fun.
Seriously.
And,
But even when I make these rules, I need you to enforce them. You know what I mean? That's what that is.
we wouldn't need you.
Yeah, I'm yelling at everybody.
No, you didn't do it.
They could just
No,
be
that's,
easy.
well, I see what you said, private case.
Easy cut.
It's a private.
I see what you said.
Is she
got you.
considering something or?
She is.
Okay.
That's why I was waiting.
I don't have the files.
All right,
Let me see what I have.
what you need the case number?
Well, yeah, I don't have that.
18 CRB 00512.
1152?
18 CRB 00512. All right, you ready? So we're going to go on the record in 18 CRB 00512, the City of East Cleveland versus Queen Tiara Miller. The charge was telephone harassment. And this is December 12th, the day prior to trial. And it looks like there's going to be a plea to the charge of telephone harassment. And I'm going to hear from counsel as a prosecutor, but it looks like there's a request for the Cycle Breakers program.
Right.
All right, so what happens with that, we'll go ahead and accept the plea. There's a period of probation upon which you'll do the classes that we have here. Once everything is done satisfactory, you come back. You don't even have to be present, counsel, then the case is dismissed. So it's not on your record. So that's just the program. Madam Prosecutor, can you make a record as to this resolution?
Yes, this case came from, Miss Miller became involved with a gentleman that had been in a relationship with another lady and had a child or two with him. A child with him, and he helped raise her. There came a point in the course of their relationship when Miss Miller, it would appear that she wanted to drive a wedge between him and Miss Butler. So she sent text messages, photos, and explicit videos, sexually explicit videos to the phone that belonged to the eldest child. At some point, Mr. Turner let Miss Butler know that, let Miss Miller know that Miss Butler was able to see these things that she was sending, and she continued to send them. Then she continued to put messages out on Instagram and say things, and went back and forth. And there was some back and forth between Miss Butler and Miss Miller. There was some back and forth between the children at Miss Miller. it needed to stop. So this is a way to have them go forward without all of that.
All right. Counsel. So let's start with this. To the charge of telephone harassment, how did your client plead?
She pleads guilty with the anticipation of being in the cycle breaker program. However, and this is the request I have of the court, she has another issue in Cleveland, and I wanted to be assured that her plea today would not in any way affect her probation in Cleveland.
Okay. So how are you going to assure that? Because I have two options. We can do the plea and I hold the finding in abeyance.
And that's what I was requesting.
And because other than that, the goal, as I mentioned with the abeyance, is that you do everything that we ask you to do on probation. And I know, that's a challenge because you have to come to classes and do those things. But once that's over, the case is dismissed, which means at that dismissal, it won't affect obviously anything in Cleveland. But if Miss Miller was to violate probation, say for instance, she didn't report, she didn't go to classes, then the guilty plea will be a finding of guilt. Is up to a $1,000 fine and 6 months in jail. That would go into effect if you violate probation. That's the key. So I'm working with you by giving you the opportunity to have this off your record. But the flip side of that is that you have to do everything we're asking you to do. So counsel, with all that being said, is the plea still a guilty plea?
Can she plead no contest with?
It would
I understand how the program works.
It would be a no contest with a stipulation to a finding of guilt in the event that
In the event she doesn't
right.
feel it.
So Ms. Miller, basically what that means, I don't want to speak any legalese that you wouldn't understand. So we can accept a no contest plea as long as your counsel agrees to stipulate to a finding of guilt, meaning that again, if you don't complete the program, it's a guilty finding. So we wouldn't go back and say, okay, in 6 months, if you violate probation, we're going to trial now. It would be if you violate probation or you don't do my program, there's a guilty finding. This is on your record. And there's the possibility of the jail time and fines increased and all that. You understand? I'm sorry?
I understand that was my whole issue.
Let me speak for her.
Okay.
What she's saying is the attraction of the cycle breaker program is not only just to help her, but she didn't want to go to jail.
Right. Absolutely. Absolutely. That's the key. And counsel, I appreciate that. And so so there's a guilty of no contest with a stipulation to a finding of guilt. So here's the deal. I'm going to accept that. And the other thing we have to do, because as you know, victims have a right to be heard. So I want us all to appear tomorrow at 9 o'clock, get the statements, and then we'll be done with that.
Now, this is why I filed for the continuance.
Oh yeah, there's
like she has to be in class and has.
When exactly are your finals?
Well, tomorrow is my last class. It's the first success seminar class, and it's not actually a final. It's by attendance, and tomorrow is my last.
What time is that class?
It starts at 9. It's over at 10:30.
All right. So in that case, Ms. McCullough, we can just have the victim come in the afternoon.
Okay.
Let's set it at 12:30. Well,
I still have to give.
yeah, we have to give time, and then what I'll do, because I'll end up rescheduling some stuff too. So counsel, will you better make it at 12:30? Because look, if we was in trial, everybody would have been here at 12:30.
We've been here at 8:30 or 9.
Look, we'd still been rolling possibly. But Ms. Miller, as we are winding this down, I think it's a good way to get the case resolved. Your attorney will tell you that, I'm just speaking freely now, that going to trial is oftentimes very risky in regard to he said, she said. And if you have an opportunity to do a few things that can only make you super better no matter what, versus risking having something on your record, that's always a good move. But Miss Ivy, you want to ask me something?
Yes, Your Honor. Normally, if someone's on probation, we know that probation department. Gotcha. Yeah.
Well, I don't think that's the issue.
But I thought she was trying to keep it from them. That's why I just
No.
want to make sure. Oh, okay.
That's not the issue.
Okay.
Because it'll be and counsel.
Unless you want to talk to him.
Nope. Go ahead.
Can she have a chance to speak?
Yeah, in fact, I can give her the entire floor now to speak, and then I can hear, I have to give that other opportunity at 12:30 tomorrow. You don't even have to speak at that point if you don't want. But counsel, so 12:30 is good for you? Can you make it at 12:30? We can do 12, 12:31. So counsel, we can do.
Can is it possible to do it on Monday?
No, we can't. We'll do it tomorrow.
Okay.
I mean, we can do it on any day. All right, so we'll do that. The other thing, just counsel, just to reiterate, so with her being on probation and with it being held in abeyance, so that's not going to mess up Cleveland, right? From what we understand.
From what we understand,
Okay.
I find differently. I think the court we could be creative.
Who's the judge on that case? Okay. So,
Adrian, it's been years. She's been on probation. Right. Right. You know.
okay. So we can, but the key is we'll work. We can do some type of communication, but the bottom line is we'll go ahead and move in this direction with that plea. All right. So
We will see you at 12:30.
yes, but you want to speak now, correct? Ladies, I'm going to have her go on the records. If you, okay, so let's go ahead, Ms. Miller. We've already accepted the plea. We know you're going to come back tomorrow at 12:30 so that we can just close it out. But this is your opportunity to make a record because I've never been able to hear your version of what occurred after all this time. You can go ahead and present that at this point.
Yeah, it was an ongoing situation in this town. After finding out that Lewis and Michelle was really together, Michelle constantly played on my phone. Even after we left him alone numerous times, it's like he just kept coming back either to my business, to my house, calling me, having his friends calling me. And I asked him before, I said, are you trying to set me up? That's how I feel. Like I'm trying to leave you alone every month, a year. And you keep trying to make it like your business. And like you need me so bad or want me so bad and knowing that I got a child that you can't protect me or my son because your baby mother.
How old is your son?
5.
Okay.
It was one time in January last year where I seen Michelle in traffic, like on Mayfield and Monticello. I noticed her car, and I didn't think she would follow me, but she ended up following me to the Marks parking lot of on Coventry, the grocery store. And I sat there just for precaution because I had my son in the car with me. And she ended up walking up to my car, and on the passenger side, she had a lock in her hand. She was politely trying to break my window with a lock in her hand. So then I tried to pull off. So she yanked up behind me. It's broad daylight on a Sunday in the Marks parking lot. She pulled up on the driver's side of me. Her daughter was in the car, her oldest daughter.
How old is the daughter?
She's 21. That's the one that goes to Spelman.
Is this the one you said the eldest child?
Right.
So
She was a minor at the time. She was 17.
She lied about her whole statement. This lady been grown.
But at least what we can agree to is that the young lady that was allegedly receiving the messages is in college at this point. Today she's at Spelman. Okay, go ahead, continue.
And may I just
Yes.
interject? This is a little defense interjection, you don't mind.
Correct.
She didn't get the number from anybody but her father. And
Yeah.
she gets the number from her father, thinking it's another phone he wants her to call on, and it's actually a child's phone. So she didn't intentionally text to the child. She was texting to the guy she was dating.
Okay.
But he had given the number and put her in a jacket.
I want to also let you know that Louis called me from every number in their household. He called me from his youngest brother number. He called me from the house number. He internet called me. I mean, I haven't seen you in Vegas with him, and that was after he wrote the statement. I mean, so two and two. I mean, everything adds up. I didn't find out about him writing a statement against me until after we came back from Vegas. And he still popped up at my house. He still followed me to my son's daycare. He told me he would write a statement saying that he didn't know all this stuff, but he knew everything. And then I talked to the other lady, and she told me his statement wouldn't matter. Did you know he wrote a statement against you? And that's how I found that out. But back to her yanking up behind me in traffic. She pulled up on the driver's side of me. Her daughter rolled down the window, and she was attempting to break the window with a lock in her hand. She couldn't break it. There was a car in front of me. I should have just caused the accident. But my son was in the car, so I didn't know what to do. Her daughter got out the car, Ryan Nathan. She hit it into the shadow, and then they pulled off. I seen Cleveland Heights Police. They normally on patrol. The patrol car sitting behind me in the parking lot. I asked him, so you didn't see what was going on? He said, no, call the police. And then he pulled up. I feel like I was in the twilight zone. I called 911. They said, man, there's nothing we could do. You have to go to the police station. I sat in the back seat crying. I had a tent on my window, so the tent held my window together. So then I pulled back to where the guy was stationed there. He act like, I talked to him when he got to the light by the Chipotle, Euclid Boulevard. He was like, I'm like, what are you doing? And that's when he told me to call the police. He's like, I'm about to go look for him. How you looking for somebody that you didn't see? Anyway, I went back to the parking lot. I had argued with him to write a police report for me. He ended up sending a backup cop that could come write my statement. He acted like he couldn't do that. That's not what he was there for. What is you on patrol for? So can't take it. So the lady cop came. I told her I know the lady. I know the daughter. I told her I knew the address. She went to their house. She said they was in the driveway. If I could get out the car, she took all their information. She said they would have a warrant out for their arrest, and she would call me once they get arrested. They never called me. The prosecutor in Cleveland Heights called me one time. Her name is Tiffany something. This case is a retaliation case. They ain't trying to prosecute.
Well, let me ask you. So, from what I'm understanding from your statement and counsel, that the number that you were texting or messaging, you didn't know it was at the time was someone else, but you did.
After they broke my window up, I knew it was the daughter.
Okay.
They was playing on my phone after they broke the window up.
And so, did you indeed send pictures of yourself or videos or something like that? I mean,
I said, why are y'all harassing me? I'm not with this man no more. I sent videos. I said, he is in the videos, moving the camera. Like, why are y'all messing with me? Like.
and just so, what are the videos that you sent? What were the videos of?
Not good, just not good.
Okay. And you said you two having sex. All right. So, anything else? I understand. Anything else? Ms. McCullough, you stood up. Is there anything you want to add?
Yeah. I'm going to speak for Miss Butler. Apparently, she has something at 12:30 and she won't be able to make it. So I just told her did she really need to be there? And I said, well, she had a right to speak at the sentencing, but I'll just speak for her.
Okay.
I understand that there was a incident in Cleveland Heights. According to her, it was charged, but according to them, she didn't show up and it was dismissed. There was another incident that did involve Miss Butler, where Miss Miller supposedly got in her car and followed behind Mr. Turner, who was driving the youngest daughter, which is his child with Miss Butler. And she supposedly almost like ran them off the road. But Mr. Turner chose not to do anything about it. He didn't press any charges. She may not have known initially that was the child's phone number that she was texting. But the day she was sending those, the girl let her know, and she continued to send them. And she continued to do other things after that. Okay. So it's not that innocent.
I sent the videos that one day that they played on my phone. They played on my phone.
That is not how you handle it. These were very explicit videos, oral sex, regular sex, pictures of them having sex outside. That's not what you send to children. I don't care what playing is going on. The youngest child was able to view it too, and she's not an adult.
Say something. When Miss Taylor first wrote this complaint up with East Cleveland, she put it on her youngest daughter. She said I sent it to her youngest daughter. She was trying to get me a felony for child pornography, saying that I sent it to her youngest daughter. She lied about the whole thing, this retaliation. I sent it to the daughter that broke my window that was playing on my phone.
Okay.
I would never, I don't know why, the lady is psychotic. Why would you even put your daughter in your mess, jeopardizing her and her future for your baby father? Like,
All right. So are you and Mr. Turner together now?
no.
Have you had any problems with the young lady since this occurred? Are they
They
still?
constantly play on my phone. The day we was here in court, she played on my phone. I had to make a police report. They told me to make a police report. I want to get a restraining order distance. Like, every time I go downtown to get a restraining order, they tell me don't do it because it can make it seem like I'm trying to intimidate her.
Well, let me ask you
I hate
this.
to have to bring this up, but Your Honor, when this case first started coming into court, Miss Miller took photos of Miss Butler while she was sitting here in court. She took She took a photo of me and posted it on her page. She took a screenshot of the complaint that Miss Butler wrote and posted it on her page. This continued on and on. Even while the case was pending, she continued to do things. She would go on one of their relatives. There was a relative, a cousin of Miss Butler, that had posted a photo of her and Miss Butler sitting on the porch, and Miss Miller felt the need to comment on that. And so it needs to stop. Now, I will say I haven't heard anything recently that suggested that this behavior has continued, but back then it was ongoing.
Can I say something as defense counsel?
Yes, counsel.
This is one of those situations that I'm so glad the court has intervened and all of it's gonna stop, okay? Because it's a love triangle where the guy who is playing both of them, he's not here. He's not gonna have any ramifications. They're going after each other on and on and on to break it down. And what my client is trying to say, Miss Taylor hasn't stopped. To this date, my client believes Miss Taylor still calls her phone and plays little games with her. So my client is feeling like she can't stop Miss Taylor, but Miss Taylor successfully has stopped her by making these complaints. So she doesn't have any way to get Miss Taylor restrained or get Miss Taylor from harassing her, but Miss Taylor's continuing to harass her. Which is not a telephone harassment issue, but it just grows and grows. And
Right.
grows.
Is the case downtown under Judge Adrian's old docket, or
Yes,
is that involving the same young lady? All right.
No, it's not true.
Tried to get a restraining order before they came to court with this, and she didn't follow through with the restraining order. If it was a real problem, she went through with the restraining order.
All right.
She feel like she has more relief in here because I feel like this is an extra protection. And I have no positive reinforcement to it, like on my end.
You got me.
All right. So this is what I'm going to do. A couple of things. So this is my turn. So we're going to go ahead and have you meet with my probation department about the cycle breaker program. The fee for the program is $700, but you have a lot of time to pay for it. You have up to a year to take care of that. I'm going to have you in my program, and Miss Ivy, the program we're starting in January, the new that we're going to talk about. So it's for ladies. And this is what I want to say, counsel. Just like you said, I'm glad the case was resolved, because now that you've entered a plea, these are facts that are difficult for your attorney. The fact, at the end of the day, it's great for me to hear everything that led up and everything that happened at the store, but probably none of that would have been presented at trial, because the city would have kept it very narrow to, did you or did you not send these videos? Was it to somebody who didn't want them? And then that's pretty much the end of the case. You see what I'm saying? So what counsel has done for you is put you in a much better position where you can get this off your record. You can explain to everybody. Miss Ivy's hearing it because she's going to be in probation. She's hearing what's going on, so she doesn't have this non-knowledge prejudice against you. We know what's going on, and then most importantly, Miss Miller, we all know what happens in these situations. And for the record, because it's come up now at least twice, you're right. I do remember at the time that I saw you in the airport. Obviously, I didn't know you and I didn't know this was going on, but I did see you and Mr. Turner together. And at that point, you know, from my recollection, we were there for a while. I don't know if the flight was delayed or whatever the case, or we were there early, but I remember at some point I saw Mr. Turner, and then when he got up to go somewhere, I went and spoke to him because I hadn't spoken to him. So I do remember all of that. And I know you and I didn't have any interaction, but I do remember being there. So again, so that even speaks to what you're saying. I know that that at that point in time, Ms. Ivory, you know, she was being wined and dined and maybe even being prosecuted at the same time. You could check those timelines. That would be interesting to know if when I saw her, he knew that these charges were, you know, pending, and he knew that he had written a statement. I don't know, but it does speak to the fact that he's the one playing the game. And the last thing I want to mention, and Ms. Ivory's going to tell you this, and counsel will too. I think when the two ladies' emotions are up, and this one now is being the one that's being the aggressor, the only thing that's going to stop that is time of just chilling out. You ignore her unless she could be, because I'm just going to take it from you. Let's say somebody's insane, but unless you are medically insane, if you ignored her for 6 months or a year, at some point she's going to feel stupid texting you. And maybe she won't. Then at that point, you file the reports. You know, if it happens in East Cleveland or another city, and I'll tell you, these officers, I'm not even sure if this officer right here, I'm just using him because he's in the courtroom, he probably doesn't even know Mr. Turner. Mr. Turner was involved in the city years ago. So, I mean, you call this officer, they'll take the complaint if there's an actual complaint of some new harassment. But time is the only thing that's going to work with you two ladies, because he's built this up so tough. The texting, the messaging, at some point, one of the two parties have to ignore the other one until it just goes away. So, when am I going to have her meet with Miss Ivory?
After that trip, he came in my bed, came in my college. He sent me pictures of him in the hotel room, and he apologized for make it up to me. He sent me pictures of his gun and roses. That was offensive to me. That seemed like he had a whole other message that he was trying to portray. Like, and I got pictures of that. Like, I don't understand how he could get off. But like, it's all on him.
Well, here's the deal. Now that this is officially over, that's another thing too. And counsel will tell you, sometimes it's challenging for prosecutors. I was never a prosecutor, but to handle multiple charges involving the same parties. Since you were charged, that's the focus at this point. Now your case is over. If there's anything that's going on where you don't feel safe, you talk to your attorney and she'll help you talk with the prosecutor. I mean, you have people now that's working in your corner to make sure that you get in a safe position. But the two of you, you and Ms. Turner, you don't have children together or anything like that, right? Never married or anything like that. Yeah, so for him, same thing. You ignore him long enough, you don't give him in, don't return his calls, don't return his text message, let him know it's really over at some point, and don't let him take you out of town, you know what I mean, under a guise of trying to make up. Let him know it's over, and at some point, either he'll stop or it is harassment that you can call the police about.
Can you let me know would I be wrong, or would I be in a worse position if I try to get a restraining order against that all the time?
I would say talk with your lawyer about it, you know, at this point, and she'll contact Ms. McCullough. I'll let the attorneys talk, and maybe at this point, if there's something else going on, that would be, but I'd have, you know, that would require a whole different hearing.
Or she could go to domestic relations and do it if she.
With against the young lady? You're talking about the young lady. With domestic relations doing it? I don't. Yeah, it wouldn't be. Yeah.
Protection order. Well, yeah, they'd have to. She had to go through the general.
Yeah, it'll be
They
general.
send you to common police court for the hearing, but I'm saying.
Okay,
She
so
could go through.
she can still do that?
Relations to get
She can go
protection
through
order.
domestic relations. She'd have to go through general procedure.
That's what I'm
Yeah,
Okay.
I'm just saying she can do it downtown.
Okay.
Right.
All right, so yeah, that wouldn't be right. All right, so we're done. I appreciate everyone coming in. Miss Ivory, you're going to speak with Miss Miller before she leaves. What day is that again? December 23rd at 2:00.
Oh, are we supposed to be back here?
No, that's when she's going to meet with probation. So we're done. You don't have to come tomorrow. You're in good shape. All right.
And we're not on for 12:30.
We're not on for 12:30. We're not on at all.
Thank you very much.
Thank you. Appreciate you.
Did y'all come up with something?
Yeah, I thought we had.
Hold on one second.
We didn't, so.
All right, so we.
I'll let her speak.
All right, give me 1 second. So we're in 19 CRB 01319, the City of East Cleveland versus Shayla Rosado. And again, it was resisting arrest, obstruction of official business, and disorderly conduct. We're set for trial today. In regard to whether or not we're going to go to trial, Ms. Rosado, are you ready for trial, or what's the status at this point?
Yeah, that's why I would like to request a continuance because I feel like I'm not being adequately represented.
All right. Now, Ms. Rosado, here's a couple of things, and counsel knows this too. Whenever you are facing the possibility of jail time, you have 3 first-degree misdemeanors, which means you can get 6 months consecutively, meaning you could spend that time over and over and over again until you serve the time, and $1,000 fines. Because of that, I do take seriously your right to be represented to the best that you feel, the best of your ability. So I don't take that lightly if you're saying that's the situation. The only other problem or challenge that I have is that we only have one other defense attorney that's able to represent you. So I can reset this so that you can start this matter with that defense attorney. But at that point, you know, if you're not hiring your own attorney, that's where we are. You understand that?
Yeah, I would like to say this on the record.
Go ahead, please. Absolutely.
I think Ms. Rosado, I think she's uncomfortable with the fact that as I advised her, whenever you go to trial, it's always a roll of the dice. I cannot sit here and guarantee an outcome.
That's right.
And she asked me some questions, and I'm not the type of person that pulls any punches. I just tell her like it is.
Okay, and that's fair.
I don't think she was happy with what I told her, but I'm not going to sit here and sugarcoat.
Okay.
Because it can come back to bite me.
Absolutely.
So I'm just not going to do it. So she wants another attorney, fine. An offer was made, in light of the fact that the officer was here and present and ready to go. But if she's not comfortable with that, you can go forward on all 3 of these charges. Which is what I had told her, that would proceed on all 3. And there was a risk, and that, it's a roll of the dice, and she could get convicted on all 3 counts. It's a possibility. I can't guarantee that she won't.
Your Honor, if I may.
Hold on 1 second. Well, at this point, no, because I don't want to talk. Either you want a new attorney, which I'm willing to give you the opportunity because you are facing, you know, jail time, and I will grant that one opportunity. We have one other attorney we can assign it to. I know that's an inconvenience to the city and officer, but I appreciate your patience and willingness to work through this. We'll just reset it. There's no point in debating. And Ms. Conwell was able to make an adequate record as to why what she did is representing you. But I'll give you that opportunity. And mainly you have it because we just happen to have that leisure. There's some courts that don't have multiple defense attorneys, so it would be difficult. But I'm going to give you that opportunity. What date? So December 19th is a new pre-trial. So that other attorney can get intimate with the facts. Officer, you know you don't have to be here for that date. December 19th at 9:30? All right, we'll see you back then. We'll give you a reminder.
Good luck.
Hold on 1 second, Pat.
Okay.
And other than that, court is adjourned. Thank you, everyone, for this day. Well, no, yeah, but you know, December 19th.
I know. I mean, you know, because she's in school, she told me what she wants to do, and I said, hey, there's a risk. What does she want to do?
She loses.
She said she's in school studying psychology.
I want to know what
I said, you know, if we're talking about going there as a profession,
you gonna get
you gotta take a license.
like if you try to, try to, you can do it.
Seeing somebody.
That's a good choice.
Right.
Beg your pardon? She's got 10
I just learned.
Oh, menacing. Oh, well.
I mean, say, listen to me first.
Well, what do we do with strangling, assault?
They do.
Strangulation.
No, so because you know what? Because I get one, like for instance, there was one agency that sent me something and said, "Hey, we no longer want these. You don't have to send them to us anymore." Yeah, they send them out. For what?
The arrest record.
Oh, the arrest itself. You're not talking about the other one,
Right.
Oh yeah. Should we send them to the other?
Yeah.
Okay. See, I didn't know we weren't, but we'll make sure we're doing it.
When it comes off of January 16th, we have it, the other agencies don't have
Let me check with Laura because I didn't think she knew a distinction, so I thought she was sending them everything.
Okay.
I think she should be. She probably didn't know not
She
to.
probably didn't because someone told me she wouldn't do it.
Let's find out. But I know the other ones are. But you're worried about that.
Yeah.
Okay, makes sense. Let's check.
Because if you're not getting to the right age assistant, remove them.
Right. All the other ones are. Because I can't remember which one said remove us from the list. We're no longer in need of receiving these.
Okay.
Because there's a group that she sends them to.
Right.
But I'll find out if she's doing it for those two.
Okay.
All right, thank you. She'll be in tomorrow too.
I don't know what you know. I remember Detective Tom.
Oh yeah. So here's what's funny. The reason she kept throwing out that Vegas thing, I was